project you all in the back. If you're, I made these folks move up because they sat back there. So if you can't hear me, just scoot your chairs this way. There's not a lot you need to write down, but and if you can't hear me, just raise your hand and I'll try harder. But I am here to talk to you about student accommodations. I know that this is something that you have been trained on before. Some of this stuff will be things that will not be the first time that you're hearing it. But I work for a firm and I do a lot of employment litigation and advice and counseling, and that extends also to student accommodations and OCR complaints and different things like that. So that's why I'm here to talk to you a little bit about the legal aspects of the student accommodation process. I know everybody knows that there's a policy that says that we don't discriminate and that we accommodate students with disabilities, but we're going to talk a little bit about the legal considerations and how that all fits in with the district's policies. So the sources of the legal rights for students, disabled students, comes from Section 504 of the Rehabilitation Act of 1973. That was actually the first statute that provided disability civil rights protections in the United States, and it sort of laid the groundwork, so to speak, for the ADA. Obviously the ADA is probably something that you have heard of, was passed in 1990. It was amended and sort of expanded to some extent in 2008 through amendments. And Title II of the ADA is the section of the ADA that we're talking about here today that applies to local government entities, which includes colleges and universities. So just, kind of taking each of those statutes one by one, 504 says that no qualified individual with a disability in the U.S. shall solely for the reason of their disability be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any program or activity receiving federal financial assistance. There was a case about a decade after the law was passed that specifically said that includes any entity that receives federal financial support, including federal student loans. And so it's very broad. Almost every private and public institution is covered by Section 504. The ADA has similar but slightly different language, and it says essentially that colleges are prohibited from discriminating against individuals with disabilities. Okay, that's probably not news, but the harder part is they're also required to provide reasonable accommodations, academic adjustments, and auxiliary aids, which would enable the students to participate in the academic programs, unless doing so would cause an undue burden on the college. And we're going to talk a little bit about what that means. First, we need to talk a little bit about what is a disability. So the definition of disability under the ADA is a physical or mental impairment that substantially limits a major life activity. That's the person themselves being disabled, and we're going to talk about what those individual pieces mean. Having a record of such an impairment, which could mean that they had a history of cancer or some other disabling disease or something that they're not currently suffering from, but they have a history of it, they have a record of it, and if that is known, you are not allowed to discriminate against that person for their record of having a disability or being regarded as having a disability. That one's even harder, because in that case, the person does not actually meet the definition of disabled. They are not substantially limited in a major life activity, but we are regarding them as being disabled. We're treating them as if they are disabled. And that becomes a problem sometimes when people make assumptions. You're making an assumption about what somebody is or is not capable of, perhaps without the college, maybe not you individually, but the college receiving medical documentation from the person's healthcare provider that says that they're disabled.
Kristin, can I ask you, do you mind if we stop and ask questions?
Sure, that's fine.
Can we go back just on the requirements of the ADA? One part of that was academic adjustments. Is that defined?
Yeah, we're going to talk about that
Okay,
for
thank
sure. I've got examples and things like that. It doesn't have a quote-unquote definition that says this is exactly what it means, but we're definitely going to talk about it.
Can you go back to the previous slide for my question? The mental impairment, is that include PTSD for veterans?
Yes.
Okay, that's what I thought. Thank you.
Sure. So substantially limits, this is not a groundbreaking slide, but it means that you either cannot do it or you're significantly restricted in doing the major life activities. So what are major life activities? Well, the EEOC, which is one of the agencies responsible for enforcing the ADA, says that a major life activity is caring for yourself, performing manual tasks, walking, seeing, working, speaking, breathing, learning, hearing. There's sitting, standing, lifting, reaching. Those can be major life activities that you can be substantially limited in. And, you know, kind of in the context of the educational context that you might come across, you could be limited in your ability to think, to concentrate, to interact with others. Those things also are major life activities. When the ADA was amended in 2008, they expanded the definition of disability to include things like major bodily systems, your digestive system, your circulatory system, your endocrine system. You know, all of these things can be major life activities that can be substantially limited. So concentrating, thinking, communicating, learning, all of those things are things that can come up in your context. And since 2008, the number of things, to your point, that would be considered a disability under the ADA has been expanded substantially. You know, the things that you all might come across in your teaching or administering here would be learning disabilities, dyslexia, ADD, ADHD, hearing or visual impairments, limitations on the person's ability to ambulate, and, you know, like I said, almost anything would be considered a disability, maybe with the exception if something's very temporary. That is not going to be considered a disability under the ADA. So if you break your foot in a car accident and you need to have surgery for your foot and that's going to heal at the end of that surgery, that is not going to count as a disability under the ADA. Does it mean that we need to mistreat that person and, you know, none of these general principles apply? No, but the legal definition of disability would not be met in this instance. Okay, so we talked, or I mentioned earlier that in addition to not discriminating against somebody because they have a disability, or a student because they have a disability, we have an obligation to provide them with a reasonable accommodation. That language comes from the ADA, and so the idea is, well, what is reasonable? Number one, it has to be effective, and that really is the key piece here. And what I mean by effective is, if you do it, then it ought to allow the student the ability to participate, get the benefit of all those things at the beginning that we talked about of your program. And if even after giving them that accommodation, they are not able to participate, get the benefit of, or whatever, that disability would be considered not reasonable. Because the idea is that they would be able to participate fully in our programs, course, you know, whatever the case may be, if we gave them the accommodation. And then I mentioned earlier, as long as it doesn't create an undue burden. That's always a big topic of discussion. What is an undue burden? Well, technically, the definition is one that results in significant difficulty or expense. And I would venture to say that every client I've ever had has mentioned to me that whatever accommodation has been requested is a significant difficulty or expense. And I can tell you that the Department of Education almost never agrees on a cost principle. So keep that in mind, that sort of exception is there, but you can almost never rely on it. And we're going to talk a little bit more about the undue hardship and some examples and things about that. So one is significant difficulty or expense. Two is if the accommodation itself would result in a fundamental alteration of the program, of the service, the program, the activity, and then there's the undue financial or administrative burden again, then that is not a reasonable accommodation. And we're going to talk a little bit about the fundamental alterations as well. And it's really a case-by-case basis. So there is no bright line rule out there. There's no handbook that I have at my desk that says, oh, you know, take-home exams is per se a fundamental alteration. You know, that's not the case. There is no handbook, there's no index, there's nothing we can point to say, yes, this is going to be reasonable, and no, this isn't going to be reasonable. You know, there was one case that did find, for instance, in a law school that giving a take-home exam was a fundamental alteration of that program. So the regulations talk about a lot of different considerations when you're talking about the cost of the accommodation to the university or the college. And so you're talking about the, you know, what is the nature of the request? What is the cost at a very high level? What is the cost, or what are the overall resources, not only of the college, but of the district? So it's not a, what does this student pay in tuition versus what are we going to have to pay to, say, get this interpreter or whatever they are requesting. So it's a much broader analysis. You can talk about, you know, legitimate safety requirements, other effects kind of on the program more broadly, but just keep in mind it's not sort of a apples to apples, you know, this person isn't paying that much, so we really shouldn't have to spend X amount of dollars to accommodate them. If we're talking about this, the kind of overarching categories of accommodation, one is access. So can they get in the door? Can they get in the classroom? If it's an online classroom, do they have access to the programs and are able to use it with whatever disability they might have? And then modifications to academic requirements and policies. And then auxiliary aids and assistive technology, which we're going to talk more about. So Dr. Dadia, talking about academic adjustments. These are some examples. Again, there's no quote-unquote definition to say this is what academic adjustments are required, but you might have to extend a period of time for somebody to complete an assignment, to complete a course, to complete a degree program entirely. There may be course substitutions in a case where, you know, instead of one course that's all multiple choice exams, there might be a more practical or interactive course that effectively covers the same, you know, substance and curriculum and just is taught in a different way that you could say, okay, yes, you know, we would allow you to swap those two and we would give you credit. An oral exam versus a written exam. Other evaluation methods depending on what your particular course is. It does not require that we provide tutors though. So that's like one sort of bright line example that's like one step too far in terms of what would be required. if we're talking about, oftentimes, and I'm sure you all would think, okay, whatever the aspect of my course is that the student is asking for either a waiver from a particular test, a particular element of a class, you're probably thinking, well, that's a core requirement of my class. We can't let that one go. We aren't required to make an academic adjustment that substantially diminishes the academic rigor of the program. So if we can show that whatever that element is critical to the program or to the course, then we would be able to say that you are not allowed to just waive that, and we're not going to waive the requirement that you complete that in order to complete the course. However, not everything is going to be essential to the course or diminish the academic rigor of the program. So again, it's a case-by-case.
Okay, and just to, I know, and I do understand it's case by case, but there are several examples that are popping into my head. And so when we talk about making adjustments, doing, oral exams versus written exams, where as an instructor, I might require that students have a written exam, but we might consider it a reasonable accommodation to give that exam in an oral capacity for that. But what if it is a program where, let's say it's a certification program, and they have to sit for some sort of a certifying exam in order to be marketable in the workplace? Is it reasonable to say that because that certifying exam at the end of this program, that's sort of, say, a state exam, are they required to make that accommodation? Or is it reasonable to say, since we're preparing you to sit for that state exam, and I know I'm going into detail, but I'm really trying to, is it reasonable to say that in this particular program, that's not a reasonable accommodation for these classes because of the expectation you will have to sit for this? Does that make sense?
It does. And so the second point here would be if it is for something that is related to some sort of licensing or certification, you're not required to make changes to that. So I realize that wasn't your question, but
Right.
So that's on one end.
Okay.
If it's a course where there's a certification at the end that the state approves or whatever the case may be, and the requirements are X, Y, Z, A, B, C, then we don't have to eliminate one of those. Your question's a little different. It's a little like precursor, so to speak, of them taking that exam. All of these are going to be an argument. We are going to have to defend the decision. And so what I think we would say is that if they are not in a position to complete A, B, and C, and X, Y, and Z when they take that certification, then eliminating that requirement would diminish the academic rigor of the program. Now, again, it depends on what that licensing requirement is or what the exact circumstance is, but that would be the argument I think we would make. So auxiliary aids, this would be if someone is visually impaired or hearing impaired. I'm sure this wouldn't be the first time you all have heard of auxiliary aids, but books on tape, taped text, readers, large computer screens, note takers. The big one here that comes up is interpreters, if that is needed in some context for a hearing impaired individual. Interpreters can be very expensive, and so that often becomes a point of contention, a challenging accommodation to facilitate and to make. There's authority, though, that basically says that the financial consideration in getting an auxiliary aid that would allow a student to participate in the course shouldn't, be the determining factor. And it kind of goes back to what I was saying earlier about the undue hardship and significant financial burden being extremely difficult to meet that burden. The other point I would make here too, and I understand, and we're going to talk a little bit about the facilitating of accommodations, and you all may not yourself be facilitating this, but keep in mind, it's okay to suggest to a student that they reach out to vocational resources, nonprofit groups, other private institutions that provide grants and funding and things like that to help with these kinds of aids. it's fine to suggest that they reach out or help them try to apply, but it's not okay to require them to do it. It's not okay for us to pass along any of the cost that may come along with that. Or say if they didn't go do that and get that resource, then we're not going to do it. We can't shift that burden. The burden is ours.
Can we suggest that they take a different format of a class that would eliminate the need for specific accommodations, say an online versus a face-to-face class, where in the online modality a requirement would be, or an accommodation would be necessary, but if they were in a face-to-face course, it wouldn't be?
So our obligation is to engage in what we call the interactive process. And the obligation is to engage with the student. The college's obligation is to engage with the student that would get them an accommodation that would allow them to fully participate in the program. So yes, but if there is some aspect of whatever that courses or whatnot, that there's a benefit of the in-person class, there's an aspect of that class, there's an interactive nature of that class that may be missing from the online class, and the student may say no, because this aspect of the in-person class is really what I am going for or need, or something like that. So we can certainly offer it as a suggestion, and the idea is we're trying to come to a solution. And so it's okay to propose things as long as, it's like if you've got two people and there's two different jobs and saying, well, do you want this job, but, this job is the third shift, in the middle of the night and it pays less and, whatever, then no, the person would say, no, I don't think that's not an equivalent to me.
I have the opposite question.
Okay.
A student who is perhaps so disabled they don't want to come to the campus, and they say, I want you to deliver this course only online, and I need an interpreter with that course, and that course is currently not built with an interpreter or a certain accommodation.
Or even in the online capacity.
Or even in the online capacity.
Probably not.
We would not have to say yes to that.
It depends.
Depends.
I know, right? You get sick of hearing that, but probably not. If, again, we would kind of go back to that's a fundamental alteration of the program. The idea is we can't have individual teachers teaching the class 5 different times at times that are convenient to the student and in methods that are convenient to the student. But we might have to figure out some other alternative. Figure out what accommodation could be made that would allow that student to come to class. Figure out what online courses exist that could be comparable, that we could give them credit and say, throw things. Switch out a course and say, well, that one isn't available online, but this one is. And, we can give you cross credit or something like that. I know I'm using the wrong terminology. Oh, see, now I broke it. All right, hang on, let's see. That's very sensitive. Okay. So let's talk a little bit about obligations. It is a student's responsibility to seek help. The student has the responsibility to say, I have some sort of limitation and I need some sort of accommodation. Although I just said that, and then if you look at my slide, it says that the student doesn't have to say, I need an accommodation. All right? They don't have to use that phrase. They don't have to use that term. But if they are asking for an academic adjustment, some sort of alteration, some sort of aid for the class, what they are asking for is an accommodation, whether they're using that term or not. So it's their responsibility to bring it up, okay? it's not our responsibility to make assumptions and say, oh, this person isn't coming to class. You know, I overheard some students talking, and I think this person may have some sort of medical issue. That's not our job. Our job is not to assume and to go digging, but that student has an obligation to come to us. But once they do, and we're on notice that they have a disability, that they're needing some kind of accommodation, requesting for some kind of modification, we have to engage in what I call the interactive process with them.
Who is we? As in the instructors or the college itself?
Yep.
So what does that define we?
Sure. The college, of which you all are agents.
So if they come to a professor and say, I need this,
The college is on notice, and we're going to talk a little bit. This is not a burden you bear alone. The district has resources both here on campus and district-wide that are really the folks who are going to lead the charge in having this interactive dialogue, in documenting this interactive dialogue. This isn't something that you have to do on your own, but yes, you are on notice, and effectively that puts the college on notice. Because if the student then later complains and says, I went to my professor and I told them I needed an oral exam because of this medical condition, and they just blew it off, then we're on the hook because we didn't engage in the interactive process. We didn't meet our obligation.
so could we, not necessarily the interactive dialogue, at that point, would be better just to say, go to student services?
Sure, you can say that, but then you ought to also, we're going to talk about that. You have an obligation to go to DSO and to go to student services and to tell them who the student is, what class they're in, what they've asked for, so that that loop can be closed. So sure, I mean, if we're going to argue it from a defense side, I'm going to argue if you tell the student, you know, here's our resource, go talk to them, and they don't, sure, we're going to bring that up. Is that going to win the day with the Department of Education?
It depends.
It probably depends, but they're not that forgiving. I saw a hand.
I asked this question in another session. I had a student to come to me after class during the first week to say that he had high blood pressure and that sometimes it might appear that he was falling asleep, but that he wasn't. So I immediately said, I think that then we need to talk to the Office of Disability, and he said an unequivocal no. He did not want to be involved with the disability. He just wanted me to know that if he looked a little sleepy, that it wasn't, you know. So then I asked at a session, and I was told that I needed to go to the Office of Disability and basically out him, you know, tell them that, you know, that this student had come to me and name him and say what it was, and after he told me no, he did not want to. So,
And this will be a perfect example of how all of these situations are gray. My reaction to that might be a little different. And the idea is the student being prevented from enjoying the benefit of the program, the participation in the program? Is he, you know, I might say, let's evaluate it for a week or two. See, you know, how often does this happen? I mean, he's giving you the heads up that it might happen, but does it happen once or twice a semester? And, you know, just as a situational thing? Or is it every class you look over and he appears to be sleeping and therefore he
not
has...
sleeping, sleepy.
Sleepy, yeah. But, exactly, I mean, so he may not be substantially limited in any major life activity in the context of that class.
He
He
ended
may
up
not...
getting a C in the class, and he was one of the leaders he was the leader in his group,
Mhm.
and he did fine. And I
Well,
never
so in
told
that
him
case,
about
to me, I didn't hear anything there that said he was requesting an accommodation,
it. Yeah, he
other
said
than
he was not- he was not
other than
requesting.
perhaps not wanting to get in trouble for looking like he was, you know,
That's
sleeping in
exactly.
class.
He wanted to give me information.
Yeah.
So,
So that's one of those situations where I think, I don't necessarily think that requires that it be reported and that there becomes a document trail or whatnot, but I think that if there was anything after that that gave you pause, that he said, oh, I didn't hear that, I missed that, I need some other, I need to see somebody else's notes because I missed something. I think at that point, it really ought to be documented. Because oftentimes in these situations, what happens is that very first conversation is nothing. But then if you go a month or 2 or 3 down the line and more things have happened and nobody took that first thing into context, then we have a problem. So it might just be that one thing, and if that was it, I would say it was probably handled. He asked you, or he told you some information, nothing ever came of it subsequently. He didn't ask for anything, any modification. So I don't think that our requirement to engage in the interactive process would have been triggered solely by him telling you that this might happen.
Just to confirm, so if the student doesn't ask you for accommodation, you don't have to talk to disability.
So again, they don't have to ask specifically for an accommodation.
Okay.
But if they have put you on notice that they have a disability, and then there is some aspect of your course that they are having trouble with, and that they are going to miss out on, or something like that, then I think that you are potentially on notice that there needs to be an interactive dialogue. And it really is a matter of having a conversation.
With
So-
the student.
Sure, you could start with the student and say, I noticed this, is there anything that you need, with respect to this? And if they say yes, then I would involve disability services and things like that. So again, it's all about when are we kind of on notice, and when are we triggered that we need to be having an interactive dialogue. All right, what else do I have here? And I said to document the request and the interactive process. So, ma'am, to your point with your student who said, hey, I might be sleepy, I might make a note of that in whatever context you keep notes, so that if nothing else happens ever the rest of the semester, you could look back and say, well, he said that one time on August 31st, then I never heard anything about it again. But then you could also then have that as a record if he came to you again on September 15th and said, I'm having a problem. And at that point, really, DSO needs to be involved, and then there's a record of what has happened. And that's really what we're trying to communicate too, is that there needs to be communication within the college, and making sure everybody has all the information and everybody's on the same page. So if you do have a student who asks for an accommodation, I would document that request in one form or another. It doesn't have to be formal, but Jim Smith on August 31st told me that he has this issue and has asked for this accommodation. That's no problem, but you still notify Disability Service Office of that. Because even if it's no problem, and you're going to make the accommodation, we need to have a record of that. We need to have a record of our interactive discussion, so that if and when something else occurs with that student down the line in the semester, or even the next semester with a different professor, then we have a record of what was the issue and how did we handle it before. Because where we can run into trouble is if somebody says, well, I want this accommodation, and one professor says, sure, no problem, and then the next semester they're in a class that's very similar, and they say, I want this accommodation, and the professor says no. And that's the end of the discussion. You can see that a student would, have that information and go and say, well, how could that be? And of course it depends, because there might be some very differences in the course. One might be a giant lecture course that's one-way communication, where having a note taker is sufficient, where somebody takes the notes and you can hand them off, and that's good enough. Another type of class might be a seminar that's very interactive, And in that case, you might need an interpreter, for instance, whereas that wouldn't be necessary in a giant lecture class. So it does depend on the circumstances, it does depend on what the class is, but if you're comparing apples to apples, we need to be consistent, and to have our disability services folks be involved is the way that we can ensure that.
One question on the previous slide. Is there an official way to document contact with the Office of Disability? Is it best to always use an email with a date and a stamp, or
Plus, it's twofold when you email. You documented the request and you notified the DSO.
Yeah, it's a double-edged sword, right? I mean, email's a double-edged sword. I'm not going to tell you that an email is required. I'm not here to make demands or requirements that way. My point is that what the district's obligation is, and that we would have an obligation to prove it at some point. So I'd probably prefer the email or some, writing that we could point to say, we were having the communication. I was talking to the student. Here's what they were saying. And I don't know what DSO exactly does in terms of their files and their documents, but the idea would be is that we would be able to go back and look and see for this particular student what had been requested, what had been done, what conversations were being had. And if everybody's operating in a silo, then it's impossible to go back if a student the next semester has a problem to think, okay, what happened? What was the situation there? Unless they're kind of all in one place. So I suspect that if you called DSO and spoke to one of the folks there and said, I've got this issue, here's what happened, they would document it. But it can't hurt to have the email. It helps to refresh your memory. Frankly, down the line, if the complaint comes 6 months later, exactly sort of what that timeline was and what your wording of it was, because sometimes that can be significant. The key here, though, is that this is not your obligation to handle on your own, right? I mean, the student comes to you, it's a challenge to figure out what to do, but this isn't something that you have to figure out on your own. We put a link there in the slides. The district has a disability services website. There's resources that are there that you can access, but really just call down or shoot an email.
I don't know if anybody else feels this way, but kind of, DSO is a little bit scary because all you think about is lawsuit when you hear DSO. But our disability services office is great. I emailed them at the end of the class and said, this is what a student just said to me about needing an accommodation. I got a reply right away. Ms. Donetta came up, met with the student, took him out of class, and the next thing, like 30 minutes later, yeah, we're not going to act on that at this time. So I felt really good, and it was like, oh, okay, so I don't have to deal with this. I don't have to try to figure out whether this is the right or whatever. So just email them and make your life simpler.
They're a resource for you. And the whole idea of all of this is to be preventative, right? I mean, I know you said I'm certain they're involved if there are complaints and lawsuits and all those big scary things, and that's what everybody thinks when I show up. Is that there's some, really something terrible, but the idea is if you have some of this baseline knowledge, I think of it as learning the red flags. Learning the red flags and hearing what somebody's telling you and saying, oh, we kind of heard about that. I think I need to call DSO. And get them involved and let them help in having that interactive dialogue, to your point, so that you don't have to make those decisions all by yourself. Now, you're an important part of the discussion because you know the class, you know your course, you know the requirements, you know the program. But here's what DSO will do at a high level. They're the ones who would be gathering any medical documentation that we need. Students do have a responsibility to provide us with medical documentation so that we can A, confirm that they qualify for a disability, and most of them might, kind of on the surface, but also to figure out what accommodations the medical provider says that they need, as opposed to what the student has just determined for themselves that they would like. So what does the medical provider say? So that's not your job. You shouldn't be gathering doctor's notes, let them do that. And they're gonna partner with you, with the administration, and the student to figure out what accommodation is possible, what alternatives exist, and have that interactive dialogue. Because we don't necessarily, sorry, I'm sounding really nasally, that we don't necessarily have to give the student the exact accommodation that they have asked for. We have to give them a reasonable accommodation that is effective. So, they may want an interpreter, but a note taker may be sufficient. So that is an interactive process. That is a figuring out what kind of class we have. That is an interactive discussion between all of the sort of parties involved. And then there's going to be work. You are then going to be responsible to some extent to implement whatever the accommodation is in your class, and work with the student. And this is just the lawyer talking, but document. Because we're often doing things that are helping students, and we're going out of our way, and we're offering different suggestions, and it's good to have all of that written.
So I'm sorry for all the questions.
Okay.
But, so let's say we're in week 14 of a 16-week semester. Student has not said anything up to that point. There's been no registration with DSO. There's been no verbal indication, whether they say accommodation or any indication. But then week 14, the student comes and says, I need X, Y, and Z accommodation. Are we required by any facet of this law to then retroactively, for example, let them retake exams in a different format, or to?
Probably not. And
But
again,
it depends.
I know, right? Probably not. I mean, was it yesterday, whatever this test was,
Right.
and something about that test triggered that, oh, I've got this issue, and it has come to my attention, being the student, that this was a problem yesterday, and, that might be one situation. I don't know of a scenario where we would have to go back and allow a retest. Again, the student has some obligation here to put us on notice. So I would still say it's case by case in terms of what has transpired in the class, how much they're requesting to go back to do, but I don't think it would be a complete do-over of the class at that point. Okay, so this also probably is not anything that is earth-shattering to you, but it's worth mentioning that the district's policy on non-discrimination, and it's FFDB local, where this comes from. It doesn't say it on there. But you can find it obviously easily on the district's website, the TASB website. We prohibit discrimination based on disability and harassment based on disability. And it's defined here, discrimination against a student is conduct directed at the student on the basis of the disability that adversely affects the student. Keep in mind too that it's not just on the basis of the disability, but also on the fact that they are asking for an accommodation. It's kind of an overlap, is it discrimination or is it retaliation? Either one of those, might fit. But taking an act against a student because they are asking for some sort of modification is also considered illegal under these, illegal under the statutes we talked about earlier, and also prohibited by the district's policy. And obviously harassment, physical, verbal, nonverbal conduct based on the student's disability or the fact that they're asking for an accommodation that's severe, persistent, pervasive, and it's limiting the student's ability to participate or benefit from your class. so to speak, as the faculty member.
I have a question.
You bet.
On the previous slide, the nonverbal. Here's an example. Student comes to me in my office. I serve as a supervisor of faculty. And the student will say, my teacher doesn't call on me. I want to answer the question, but they don't want to call on me. It's kind of there's plausible deniability there, but it's how do you handle that?
Sure. So, excuse me, harassment is a very difficult thing to define. Likely a single instance or a couple of instances of not calling on somebody is probably not going to rise to the level of harassment. Unless the reason the faculty is not calling on that student is because the student has some sort of speech impediment or some other factor that makes it more difficult for you to call on that person. And if that, over the course of the semester, impacts the student's ability to participate and to get the benefit of the class, they're going to argue it's harassment. Now the question is, what other factors exist out there? Has the professor in this scenario done other things? Because that's often what happens. If you look at a single scenario and a single fact in a bubble, it's probably not going to rise to the level of harassment. It's not going to be severe, pervasive. That alone isn't going to impact their participation. But if the faculty member ignores every email from that student, if the faculty member says snide remarks behind the student's back, if the faculty member is doing other things, what happens is all of those things get piled up together to say that I have been harassed and that my participation or my ability to benefit from the class has been impacted. So it's hard to say. I mean, one thing may not, but it's probably worth a conversation with the professor in that instance if the complaint has come to you, to say, hey, this particular student mentioned this. Is there a reason why that is? And if there is some sort of physical or mental limitation that's getting in the way, that's a trigger to have some kind of interactive dialogue. Maybe try to get the faculty member to allow that student to participate in that way as an initial matter, and then see how it goes.
On the other extreme, there are students who don't want to be singled out. So, but some sort of dialogue with the student to see what are they comfortable with. There may be a student who does have an impediment, speech or otherwise, and they're not embarrassed about it. I want to participate. We obviously have to allow them to participate. Well,
yeah, the idea is that you're going to treat all students the same, and there may be lots of students in your class that prefer either to get called on or not get called on that don't have a disability. And so how do you handle that? Do you always oblige and say, okay, if you don't want to be called on, I'm not going to call on you? Or is there some aspect of your class that requires some sort of interaction and a dialogue, and where even if your student doesn't want to be called on, that they're going to be called on? And so, I would across the board say treat everybody the same, unless someone comes to you and says, I have PTSD, or I have an anxiety disorder, and when you call on me, I am not able to, articulate my thoughts, and so my preference would be that you not call on me. That is asking for a modification to your program requirement that everybody, participates, and I think that's probably worthy of letting DSO know. I mean, that one's probably just a one and done, like, okay, but it's documented and we have a record of what we've done there.
Just curious, do y'all recommend that the faculty member check in at some point in the semester with the student, just to say, is everything going okay? Or do you feel like you're being accommodated?
So I probably wouldn't put it in those words. I probably wouldn't say you feel like you're being accommodated. Just as you said first.
Oh, okay.
How's everything going? We talked about at the beginning that you would like to not be called on, you know, I haven't been calling on you, has that been working out?
Okay,
It certainly can't hurt, and if you do it, jot it down.
okay.
Because it's great to have those markers to say, I checked in with Jimmy, you know, on November 1st during the semester, and he said everything was going great. So that if Jimmy has a problem on November 5th, we have a record that on November 1st, he said everything was fine. So what happened between November 1st and November 5th?
Right.
Yeah, I mean, am I gonna give you a requirement that if somebody asks that you have to go check in on intermediate intervals? No. But again, the whole idea is that we're having an interactive dialogue. And so I think in a lot of circumstances, that's exactly the right thing to do. Just to check in, like, hey, is that going okay? Because sometimes there may be things that the student's thinking in their mind
Right.
and things they wish were going on and would make the situation better. And they're either afraid to bring it up or something like that. So I think that can be a good idea.
So Kristin, would you agree that in most cases, if we're doing things that are just best practice for all students, that we're covering a lot of these issues? Does that make sense?
Exactly, and so that's what I say about the student with the broken foot. I mean, the chances are, you know, if the student needs to sit in the front row and they've got a broken foot, they don't qualify as having a disability under the ADA, but you're probably gonna let them sit in the front row, you know, unless there's some reason not to. The idea is that you're, again, treating everybody equally, unless there's somebody who has asked for an accommodation that would alter that plan.
What about a student that is pregnant?
Pregnancy itself is not a disability. We would also kind of have a similar philosophy, I think, that would say, well, whatever we are doing for other students, we would do for that student if there was some requirement that needed to be altered.
The student, I have a student this semester that is pregnant, came to me after last time that we had this seminar. Wow, it was temporary, it was pretty frightening. But this student just came to me and said she was pregnant, just wanted to share the good news. Not
Just an
was
oversharer.
asking for accommodations or anything like it. Just wanted to say, good for you. Just
I'm
share.
sure you guys, I'm sure you don't have any other oversharers in this generation at all. So you know what, I would just file that in the back of my mind and put it away and say, congrats. And then wait and see if there's a point at
I
which,
do ask, how's everything going?
that's fine.
Send it.
Just as you would for anybody else who said they had any, you know, anything. Some people are just oversharers. Do you have a question?
I did have a question because I remember at that session that they had said that pregnancy was a temporary disability that still needs to be documented. And like you said, like the broken foot, or like a broken hand, and then, for example, like they can't write. What if it's the hand that they write in, or something like that? That all of that should still be sent to the disability office, and you should still, even if the student doesn't ask for accommodation. And I had a student the same way, you know, just that she was asking me because she was in my class when I was pregnant, and she was like, how's your baby? By the way, I have the baby. And I'm like, oh, good. Now what do we do with that comment?
Yeah, so I'm gonna be real honest, I wasn't at that training, I don't know who conducted it. I would probably err on the side of following that recommendation, that if the district, someone at the district has said that disability services ought to be notified if you've got a pregnant employee, then do that. But again, that in and of itself doesn't qualify under the legal definitions of disability. You know, does that mean that we don't treat them the same? And again, really, I think that the question is there a request for a modification? Is there a request for something different to be done? You know, and in that case, it might be, I'm gonna miss a test because I'm gonna, you know, give birth to the baby, or I've got a, you know, like a very specific, you know, medical appointment that I've got to meet, or something like that. So I think in general, you would treat it the same.
I think there's, we've gotten different kinds of trainings over the years.
Sure.
And Title IX which is gender discrimination, might be, we might be getting a couple of trainings here mixed up, but from what I remember of that training is, if the pregnancy is maybe perhaps a difficult one where the student have to go to the doctor more often.
Complications from pregnancy often do qualify as a disability. But to your point of the student who just says, I'm pregnant, to me that doesn't immediately trigger anything. Now, if they say, I've got high blood pressure and I'm pregnant, and I've got whatever the other situations are, then those things would trigger all of the official legal.
What about obesity? So, and I'm thinking the pregnancy issue brings it to mind because, and I'll use myself as an example. This was many, many years ago, but I was pregnant and I was quite large, and the classroom had very small desks in it. And I approached, it was a female professor, and I felt comfortable to ask if we could bring a small table in because I could no longer fit in the desk. And that wasn't an issue. They did that, and in fact, one of the other ladies came and sat with me, so I wasn't by myself at the little table. But it didn't have anything to do with this kind of thing at the time. But I'm thinking now, in today's day and age, if we have a classroom that has seats that are a certain size that don't accommodate someone who's growing through pregnancy or an obese person who might not fit, would that fall under?
So here's where the DSO is your friend. And again, I don't sit in their office day to day. I don't know their exact practice. At least in the world in which I see it, and I don't know about OCR's position on obesity, so have that disclaimer. But in general, oftentimes what happens in the cases I have seen, it's not just the fact of obesity, it is some underlying condition that causes the obesity that would then qualify as a disability. So it's part of the conversation, I think, that DSO ought to be involved in. And there's a judgment call to be made. I mean, are we going to make this student go to their doctor and bring us something that says they have some medical condition that's causing their obesity because they need a bigger desk? Or are we just going to give them a bigger desk? But again, I think that's DSO should be involved and have that conversation. We do have rights. We have the ability to go ask for documentation, but it's often a judgment call of when we do and when we don't. Okay, so another policy to mention is FLD local. I think the reference to maybe got deleted, or on the next slide. So FLD local talks about internal complaints. And students have the right to make both internal complaints about the fact that we are not meeting our obligations under 504 or the ADA, or to make those complaints externally. So just talking about internally, FLD local says that if a student has a complaint about how we're handling a disability situation, if they've been discriminated against, harassed, aren't getting what they need, then they should direct their complaint to the administrator of the DSO or to the equivalent person who would be in charge of that. And the DSO is in charge of facilitating that internal complaint. And if there's no resolution there, then they can have it heard by an appeals committee by submitting a written request to the VP of Student Development. And so that's in the district's policy. There's specific rules set out there that the appeal has to be heard within 10 class days unless there's an extension by agreement. The appeals committee is going to make its findings and send the decision to the college president, and then the student can seek review of an adverse decision by the appeals committee through the college president, and that's sort of where that process ends. They also have the right, like I said, to make the complaint externally, and most likely where they're going to go with that is the Department of Education, Office of Civil Rights. So if you hear OCR complaint, it's the Department of Education who is hearing that complaint and adjudicating that complaint. They are the agency that is in charge of enforcing these laws that we've been talking about today. And the student can bring that complaint up to 6 months after whatever bad thing happened to them.
And they don't have an obligation to go through the internal process prior to filing the external.
That's correct. They do not. If they do, though, it's actually a different timeline, so the 6 month doesn't apply. And I forget if it's from the decision of the appeals committee or from the president, but they have a shorter timeline if they did file an internal complaint, but they do not have to. And it is their right to be able to go to OCR and to make that complaint. And OCR themselves there will be an investigator and they will look into whatever the issue is. They may gather information and documents. And again, when I said earlier, if we've been asked or if our obligation has been triggered, then it's our obligation to prove what we've done and how we've handled the situation. Lastly is that retaliation, I mentioned this earlier, is prohibited. And that means if somebody has made some sort of complaint internally or externally, we cannot take any action against them because they complained. Similarly, if they have asked for an accommodation, we cannot retaliate against them or treat them differently because they asked for some sort of modification, or in our mind they're making us teaching our class more difficult, or whatever the case may be. I think that's my last slide. I think we've been taking questions throughout, but the last thing I would mention is that there are damages under Section 504 and the ADA that can be both applicable to the district and to individuals if there is intentional discrimination going on. And intentional is a hard thing to prove, but we're going to be under scrutiny when one of these complaints is filed, if a lawsuit is filed. So think about how you are communicating with the student. Think about your tone, how you're reacting to them, maybe perhaps in relation to a different student or your star student, because those are the kinds of things that the student is going to bring up if they file some sort of complaint. And again, we're on the hot seat of having to prove what we did and how we did it. So just keep that in mind, document, use the resources that are available to you. You're not alone in having to handle some of these more difficult situations. And when in doubt, ask questions.
I got a question. Earlier you said that the seminars might request translators. I can see that for sign language, and of course I teach Spanish. So that's where my question comes in. What if I have a student, which I'm in March, and not only in this mainly seminar, what if the student requests a translator from English to Spanish, or Spanish to English, being that they have Spanish? Would that be a disability that is recorded?
I don't think so. I don't think so. I don't think they've put us on notice unless there's some very bizarre, it's possible that they could have a learning disability and maybe there's a situation where we would be required to accommodate, but just somebody saying it would be convenient for me to have a translator in my office all the time. But I don't have a particular disability that would need to be accommodated. So this is where you have to keep your eyes and ears out and see if you're hearing something else along the way. If the student is mentioning, well, I have dyslexia, or I have some kind of other learning disability that makes this more difficult for me, or something, in which case call DSO and let them sort of have that dialogue and figure out if there is anything there that needs to be accommodated.
Okay. I got another question. Now you mentioned it. Once upon a time, a student who came up to me and said, I have dyslexia, but I don't want disabilities to know because I want to power through. She has disability, she has identified that dyslexia since she was in 8th grade. Through therapies, she wanted to power through. So I probably made a mistake not to notify the DSO. But to whom is my field sharing responsibility? To the student or to the college? Just in case it escalates to a legal situation.
Well, so generally it's probably to both, but again, I think that would be a situation where if you had seen some problem, with the student and observed that that student was having a problem as a result of the disability that they put you on notice of, I think that would be when DSO ought to be involved. Now, the student may, if DSO is involved, they may have an interactive discussion with that student, and that student may say, I don't want anything. We're not going to force things on them. But what we don't want to have happen is the student to be feeling like I need something, and they, for whatever reason, feel like they aren't getting it, they can't talk to people about it, and they're just swallowing it, or hiding the fact that they need something because we're not having the conversation. Dr. Dottie, I think you had one more.
I do, but it's so complicated. I know it's going to be an it depends kind of thing, but it's troublesome to me when thinking is listed as one of the major life activities, and we're talking about an educational setting. So, that's where I have some challenge with, someone who has ADHD and has trouble accommodating, to me, is different from the broad major life activity consideration of thinking. Because if your course is rigorous and someone is saying, however they're saying it, that I'm not able to perform, do you see what
the key, I think, in that situation, in some of those extreme situations, is the idea is the accommodation needs to be effective. So whatever we're doing, and maybe it's giving them more time, or maybe it's something, it allows them to get it done and to complete the course.
Right.
There are going to be
cognitive-
situations
okay.
that the disability is so severe that there is no accommodation that could possibly allow the student to complete the course, to get the benefit of the program and whatnot.
Okay.
But that is
We would not be,
you aren't making that call.
right, okay.
But that is an analysis, I think, as part of the interactive process that you've tried a couple things. Try the more time, or try the note taker, or try the whatever, the case is. And if eventually the idea is it's not helping and the student isn't able to actually engage and participate and get the benefit of the course, then our argument would be whatever is being requested isn't a reasonable accommodation because it's not effective. It's not working. There's nothing that would work. Now, it's a high threshold,
yeah.
but there are situations, and I'm sure you can imagine them, that somebody has a particular disability that just simply cannot be accommodated for whatever program they are wanting to participate in.
Yeah.
You
I'll
can
just
call
leave
me.
it, I'll leave it at that.
All right, well, I've kept you over, and so I will let you go, but I appreciate your attention and your